Assalamualaikum everyone. How are you today? Hope that everyone is doing fine and safe. Alright, for today we are going to proceed with the new chapter under chapter 3, Remedies for Unlawful Public Authorities Action. Okay. Alright, you have learned the judicial review, okay, in regards to the subsidiary legislation made by the public authority as well as the discretionary power, okay, or the decision made by them. Okay, what if these powers, okay, these powers are given to them and they have go beyond of their power. Okay, whether there are any remedies available to innocent party. Okay, normally if you notice in a past year question, it's always ask a student to discuss to advise the parties concerns. Okay, the parties normally known as innocent party here. Okay, so once you advise these parties, okay, some question will request you to advise on the remedies as well. Okay, alright, these are the learning outcomes for today's lesson. First, at the end of the lesson today, you are able to know and recognize the remedies under the administrative law. Remember, we will focus on the remedies under administrative law. Second, to understand the purpose of each remedy. Third, to distinguish which remedy to apply in a situation. This is because different situations need a different remedy. Okay, and last but not least is to determine the requirements of a remedy. Based on Latin maxims, ubi jus ibi remedium. Okay, so what does it mean by this maxim? Okay, so we proceed with the introduction. Okay, basically this chapter will deal with a type of remedies which can be claimed by an individual whose right has been infringed because of administrative decisions. Remedy means to put rights or to restore. Meaning you will given certain rights to this innocent party. So based on the maxim ubi jus ibi remedium, where there is a right, there is a remedy. So if an innocent party has rights, has a legal right to take action against the other party, in other words, he also has a remedy imposed by law. In Malaysia, these remedies are acknowledged and provided for either through the common law or statute. Okay, so we have two divisions of remedies in administrative law. First, we will be looking into public law remedies, or also known as prerogative writs. They are habeas corpus, certiorari, prohibition, mandamus, and quo warranto. Next, the second division of remedies is private law remedies, also known as an equitable remedies. Okay, so for equitable remedies, it derives from an injunction and declaration. Okay, first we discuss on the public law remedies. Habeas corpus. What is habeas corpus? Okay, you need to know the. Alright, before that, for the remedies, okay, basically all you need to know is the first thing is the concept, okay, its definition, and then the requirements or situation in order to apply for these remedies. This is very important, and last but not least is the case. Okay, what is mean by habeas corpus? This is an order to release someone who has been unlawfully detained or without any legal justification. The keyword here is that Okay, that person was unlawfully detained, so he may apply for habeas corpus. And once the High Court grants this remedy, a person's right to freedom is immediately granted. Okay, so we will free himself, okay, from suffering unlawfully detained. This is based on Article 5, Clause 1 of the Federal Constitution, which states that no person shall be deprived of his life or personal liberty save in accordance with the law. Okay, since he was unlawfully detained, so he needs to seek for his own freedom. Okay, and based on Article 5, Clause 2 of Federal Constitutions, where a complaint is made to High Court or any judge thereof that a person is being unlawfully detained, the court shall inquire into the complaint, and unless satisfied that the detention is lawful. So when court discovered that the detention was unlawful or made without any legal justification, so that person will be granted a habeas corpus. Okay, the procedures to apply habeas corpus is stated under section 365 of the Criminal Procedure Code, or based on Order 54 of the Rules of the High Court 1980. So only High Court has power to grant this remedy. Okay, now this is important thing that you need to know how to apply for habeas corpus. In what situation a person may apply for habeas corpus? First, when he has been unlawfully arrested or unlawfully detained. For example, when a person is serving an imprisonment on a charge made by a court. Okay, or when a person is arrested on a reasonable suspicions for having committed a crime. This is called as unlawfully arrest. Okay, as for example, you may refer to the case of Ahmad Bashir Abdul Malik and others against Timbalan Menteri Dalam Negeri, Kementerian Dalam Negeri Malaysia and others. So in this case, okay, the appellants, okay, applied for habeas corpus after the High Court refused the said remedy, saying that the appellant should have applied an alternative remedy of certiorari. And the appeal court held that the application was for the remedy of habeas corpus, and the court should consider the application based on merit of the case and not be bothered with procedural technicalities. So in this case, the appellant's arrest was unlawful, therefore the court granted him habeas corpus. So you can remember this case for the first situation. Second situation, when there is a repetition of hearing. Repetition of hearing means where the applicant is rearrested on the same charge where he is found not guilty. Okay, let's say for the first arrestment meets against Ali. Okay, and Ali found not guilty, and then the second time he also found not guilty. So Ali may seek for habeas corpus. Okay, based on the case of Abdul Hamid bin Jamal against public prosecutor. The applicant in this case was detained under the extradition enactment. However, because of insufficient evidence, he was discharged. He was then rearrested on the same charge. Okay, take note. So the first instance, he was found not guilty, and later he was rearrested on the same charge. The court held that it was wrong to reopen the same issue again, and the person cannot be retried again for the same offence. So the applicant here successfully claimed for habeas corpus. Okay, that situation, when a person is on a bail, that indicates that he has a written permissions from the court to be out of jail until his trial for the offence he has committed is heard. Okay, so when he is on bail, he has right to apply for habeas corpus. Okay, in the case of re-incarcerance, the Singaporean court held that a person on bail after his arrest is not entitled to a writ of habeas corpus because he is not under unlawful arrest. Okay, so take note that, okay, if he was based on a lawful arrest, he was put on bail based on lawful arrest, he cannot apply for habeas corpus. Okay, but if it is for unlawful arrest, then he may apply for habeas corpus. Okay, next, situation 4, delay or continued detention. Where a person is being detained for a long period of time, one wonders whether that person can be released using habeas corpus. Basically, this is referring to the facts and circumstances of the case. As you can see, in the case of Minister of Home Affairs against Chu Chun-yong, in this case, the respondent was being kept in detention under the Banishment Act 1959 for more than 6 years awaiting banishment from Malaysia. Okay, so dia dah ditahan, okay, detained for about 6 years. As there was no country willing to accept him, he applied for habeas corpus, contending that his continued detention had become unlawful, and the High Court, in this case, issued the habeas corpus. Okay, but on appeal, the Federal Court reversed the decision, stating that the order of detention remained valid until revoked by the concerned authority. Who is the concerned authority? Concerned authority is the one who gives the verdict of banishment just now. Okay, so that authority must decide. Okay, and the next situation, under situation 5, preventive detention. A preventive detention means a person is detained without trial and verdict from the court. So there is no trial made against him. So whether he can obtain habeas corpus or not depends on the operative parts of the law under which a person has been detained. So depends on the law that he breached. From the perspective of administrative law, we will look at the exercise of discretionary power by the public body, as for example in the case of Tan Sri Raja Khalid bin Raja Harun. In this case, okay, the court granted habeas corpus because it could not be considered as an act that could jeopardize state security. Okay, because in this case, this is basically the application of habeas corpus made by applicant after he was detained by the police for reasons of state security. However, okay, it was proved that it was not for state security. Okay, and then he can apply for habeas corpus. And the last situation is a breach of procedural requirements. Still remember procedural requirements, it is divided into two for mandatory. Okay, it is against the law not to follow the mandatory procedure. If a person is detained without serving the mandatory procedure, habeas corpus can be issued because the detention has become unlawful. Okay, if it is only a directory procedure, then it will not become unlawful and therefore cannot apply for habeas corpus. Okay, so you may refer to the case of Allah Lien against Inspector General of Police. Okay, now we continue with the next remedy.